Good evening. It's my pleasure to welcome you to this evening's webinar about the Covert Human Intelligence Source Act of 2021. Just a few bits of housekeeping before we begin. With the exception of this evening's panelists, everyone else has been placed on mute, but please feel free to post your questions in the Q&A window. You'll also see that there's a chat function enabled for any other comments, any queries, any feedback. But if you can, put your questions in the Q&A and your comments in the chat function. Just so you know, the panelists' slides will be circulated after the webinar, so no need to take notes. The event is being recorded and it will be made available on the Chamber's YouTube channel. As you can imagine, there's no way to be sure who might be participating this evening, and certainly no way to be sure who might later see the recording. And that's something that you might want to have in mind when we get to the question and answer portion of the evening. Please refer to the instructions in the chat window if you have any technical difficulties. We've got someone from our team who's looking at that. So, thanks to Line of Duty and thanks to Google, almost everyone in Britain now knows the term CHIS. This evening's speakers will leave you with a better understanding of the new law, of how it will be implemented, why it should worry us all, and perhaps most importantly, what can be done about it. Our first speaker is Jacob Baldwin, a barrister at Garden Court. His practice includes criminal defense, national security, and related public law matters. He regularly provides advice and representation to both individuals and NGOs on issues that involve human rights, national security, corruption, and environmental abuses. He has been instructed to advise on appeals to the Privy Council and currently sits on the executive committee of the Bar Human Rights Council. In 2015, Jacob was a Pegasus Fellow at the Center for Constitutional Rights, CCR, in New York, where he worked on habeas corpus petitions for remaining Guantanamo inmates, worked on the CCR's attempts to secure prosecution at the International Criminal Court of those who were involved in the Bush-era torture program. And then in 2020, Jacob spent a week at Guantanamo Bay as an international observer at the trial of US and Mohammed et al., the 9/11 trial. Many of you will have read Jacob's blog post published in October of last year, where he highlighted many of the risks of what was then a draft bill. He will give us a detailed overview of the new law so that we'll have a clear understanding, and he will help set out the context for each of the speakers who will follow him. Over to you, Jacob.
Thank you very much, Susan. I'm going to show some slides in a moment, but what I want to do is to outline the new legislation, explain what it means, and also some of the criticisms of it, and to be fair, also some of the government responses to those criticisms. And then what I intend to do is consider how the legislation came about and how some of the issues, the same issues that are raised in terms of criticism, were dealt with by the Court of Appeal in a very important case that was actually brought by one of our later speakers on behalf of Privacy International, and I'm sure she will talk more about it. There's nothing new, of course, about the use of covert human intelligence sources, CHIS, or undercover agents, whatever you want to call them, in the course of police activity by the security services. There's also realistically nothing particularly new about those undercover agents sometimes being asked to partake in criminal activity. What's new about this law is that it's the first time that the legislation has ever been explicit, there's ever been any legislation that deals with authorising criminality by state agents. That in itself is quite controversial, but of course the history of using undercover agents to commit criminal offences is controversial in itself, and indeed the history of using undercover agents full stop. And certainly Kate Wilson, one of our last speaker, will be able to give some real world perspective on quite how controversial that can be. But it's worth remembering that we have in the past had the findings of the Pat Finucane report, for example, in which collusion by the security services and loyalist paramilitaries was found to have taken place, or at least strongly suspected to have taken place, and been responsible for the murder of a well-known solicitor in Northern Ireland. We also have the experience that Kate and many others have unfortunately experienced, where activists were targeted purely because of their political persuasion and their activism by undercover police officers, and were subsequently tricked into having relationships with them, all the while their double lives being completely concealed, and the enormous damage, psychological and otherwise, that has done to those women. So just to look at the new law in itself then, the Covert Human Intelligence Sources Act 2021 amends the Regulation of Investigatory Powers Act, otherwise known as RIPA, and allows for criminal conduct to be authorised in the course of or otherwise in connection with the conduct of a covert human intelligence source. Of course, we're dealing with primary legislation here. It's likely to be quite wordy, but I promise, try and break it down into more simple terms in due course. But a criminal conduct authorization, or CCA, can be granted if necessary in the interests of national security, or for the purpose of preventing or detecting crime, or of preventing disorder, or in the interests of the economic well-being of the United Kingdom. It must also be proportionate to what is sought to be achieved by that conduct. Now, I'll come on to this in a moment, but you'll notice there that the words underlined, and they were underlined by me, not by the legislation, preventing or detecting crime. Of course, we can all understand that there may be some need to use undercover agents and possibly to authorize them to commit crime to prevent or detect crime. But note it doesn't say serious crime, for example. It could be any crime. But the other criteria, of course, is preventing disorder. And I will speak more about that in a moment, but I ask you just to bear that in mind, because as we will see, disorder, when one thinks about it, can cover a very wide range of activities, many of which you may think are not those that would require someone to be authorised to commit criminal offences in order to investigate. So what does a CCA mean, a criminal conduct authorisation? The Act puts it, as I say, in quite wordy terms. It covers any criminal activity by or in relation to the CHIS, provided it's for the purposes of or in connection with the operation or investigation specified. But it also covers activities that involve criminal conduct in the course of or otherwise in connection with the conduct of a CHIS and are specified. And really what that amounts to is that the criminal conduct by the actual covert human intelligence source is authorised, but also any crime that may have been committed even incidentally by those that authorise their deployment is also covered. So provided you have that authorisation, all those, including handlers, agents, handlers, superiors, etc., are covered by this authorisation. And so what is it that the authorisation means? And what the Act says and makes clear is that the authorised conduct will be lawful for all purposes. Now, lawful for all purposes means that you have full immunity, both civil and criminal, from any action that is taken, either prosecution for a criminal offence or a civil action that may be brought by an individual who thinks that they've been wrongly treated by this particular agent or by the deployment of the agent. And that really, and it's something that we will look at a bit more in a moment, this idea of granting immunity, absolute immunity, is unprecedented. It's never existed before in the previous use of covert operatives or undercover agents, whatever you want to call them. Even when they were authorized to commit crimes, there was never an immunity from prosecution that came with it. There was, of course, an ability for the police or the security services who are using that undercover agent to make representations to the CPS, the prosecuting authority, to explain why an individual shouldn't be prosecuted because what they were doing was in the public interest. But there was never such a thing as a grant of immunity. And immunity, for those of us who are criminal lawyers and work in this sort of field, immunity is a very unusual and serious thing to be provided. There are very few circumstances in which immunity from criminal and indeed civil action is granted. There are obviously, the obvious examples, I suppose, would be things like diplomatic immunity. And we could probably have a whole seminar in which we talk just about immunities. But the reality is that immunity, as I say, is extremely rare, very rarely granted, and is a very drastic step. I've set out here some of the more general criticisms that were made of the bill when it was drafted and are still made now that it's a piece of legislation. And the first two we'll look at in a bit more detail, but the second one that's on there, of course, is that there isn't a prescribed limit on what criminal conduct can be authorised by an authorising officer who grants one of these CCAs. The only limit that's required or is imposed is that nothing authorised can breach the Human Rights Act, and what that means is that supposedly, at least, that an authorising officer, someone who has the power to grant on these authorizations, and I think Tim will probably talk a bit more about the detail of all this, can't authorize something if they believe it's going to, or reasonably believe it's going to breach the Human Rights Act. And the government have been very clear in trumpeting this Human Rights Act limitation as being a real safeguard against really serious crimes being allowed to be committed by undercover agents. The interesting thing, however, is that in other countries like Canada, for example, where they have similar legislation that deals with this kind of conduct, they do specify that the agents aren't ever allowed to be, aren't ever authorized to commit certain types of crimes. And the obvious crimes that they specify are things like murder, things like sexual offences, false imprisonment, and other things like that. And as I'll show in a moment, that was generally the thinking previously by the courts and to some degree, you would hope the general public, that the undercover agents simply can't commit serious offences. But the government is absolutely clear, was absolutely clear, that they don't want to put any limitation on what criminal conduct can be authorised. And the reason that they give for that, I'll just read out to you. And I have to say, from my perspective, it is bordering on slightly laughable, but we'll see what you make of it. There are certain organised crime groups that, in seeking to ensure their ranks are not infiltrated by cheers posing as new members, may insist new recruits undertake heinous crimes that they know a cheers could never undertake. We should also consider what happens when a criminal or terrorist group asks someone suspected of being a cheers, who is in fact not a cheers, to undertake a prescribed crime in order to test them. In a bid to protect themselves, a person falsely accused of being a cheers could be more likely to undertake a crime they might otherwise not commit. So their justification is that an organised crime group will simply say to someone, well, we're not sure about you, why don't you murder this guy, and we can tell whether you're one of us. And of course, it's absurd to think that in the past, for example, an undercover agent could have carried out that kind of act. Any organised crime group is going to know that undercover agents cannot kill people. They should, I suspect, know that they also cannot, in the name of detection of crime, go around committing serious sexual offences. And so it's a little bit fanciful to suggest that they will then use this new legislation, the Chiz Act 2021, to sniff out undercover agents. It is also slightly absurd, I have to say, to suggest that part of what the legislation is doing is protecting those falsely who are members of organised crime groups who are falsely accused of being undercover agents. That seems rather strange, to say the least. So those are the two very powerful criticisms of the lack of safeguards. That there's a lawful for all purposes, the full immunity, and the prescribed limit on what can be authorised. There's also, as I say, the low threshold for authorisation. Prevention of disorder can mean any number of things, and it doesn't say, for example, prevention of serious disorder. So those of us who are involved in process cases and things like that, and of course anyone out there who deals with that sort of thing, or indeed the general public, know very well that there are a wide range of activist groups who engage in entirely peaceful protest, like Extinction Rebellion, and the aim of their protest often is to create a certain degree of disorder, and of course sometimes they're successful, but the reality is they are peaceful, they don't commit violence, they don't really commit property damage. They are simply making a point, as one would hope in a democratic society is something that is encouraged within reasonable limits. And this threshold being so low leaves the door open quite clearly for criminal conduct to be authorised in relation to undercover agents who are and may be part of those deployed in those protest groups. There's obviously a prior issue whether they should be deployed in those protest groups at all in the first place. And what we've seen in the undercover policing inquiry is the absolutely widespread use over the years of those sorts of deployments in perfectly peaceful protest groups. So that's another issue that's raised by the legislation. Another one, of course, is that there is an unprecedented range of agencies that can now issue a criminal conduct authorization to one of their agents in the field. And that we're not just talking security services, we are talking Department for Health and Social Care, Gambling Commission, the Food Standards Agency, all this incredibly wide range of state agencies that your average man on the street, I would suggest, had never contemplated that these people even run undercover operatives, let alone allow them to commit criminal offences in the course of their deployment. So that is an entirely new, or at least in terms of bringing it into the public consciousness or public domain, it's an entirely new angle and use of these powers, and it is possibly quite concerning. A further issue is that there is no requirement for a judge to authorise one of these CCAs, these criminal conduct authorisations. So before a handler or a supervising officer decides to allow their agent to go and commit crime, no judge has to sign off on that decision, even though, of course, we're talking about decisions that involve balancing the Human Rights Act, the European Convention on Human Rights, fundamental rights, complicated issues that involve balancing legal considerations with public interest and operational considerations. The government has resolutely refused to allow that to take place. Their answer to why they don't want a judge to be signing off on those authorizations is simply that the use of covert human intelligence sources involves human beings, and that the relationship that a handler develops with a source is something that's very personal to them, and only they are likely to be sufficiently aware of all the relevant factors that would come into whether an authorization should be granted. Personally, I find that quite surprising, because we're talking, as I say, about potentially allowing someone to commit crimes and about potentially serious interference with other people's fundamental rights. And when it comes to other forms of intrusive state behavior, like intercept warrants, or in fact, any kind of warrant to go and search property, for example, then the police or whichever agency it is, they do require a judge to give authorization beforehand, and they have to meet certain criteria to persuade a judge that that's what should happen. And so it's surprising, to say the least, that that's not going to happen for the authorization of criminal conduct. And then finally, the issue of redress. So if you're someone who's been the victim of an authorization to commit criminal conduct in some way, then what is it you can do? Because there's full civil immunity, so you can't sue in the civil courts. There's no criminal. There's criminal immunity, so that no one can prosecute. And so in order to have any redress, the only avenue, and the government says it's a perfectly good avenue, is to go to the Investigatory Powers Tribunal, which is a partially secret tribunal, and one that has a 12-month time limit on claims. And so that is, and Kate will give us more insights into that, because she's actually taking a case in the IPT at the moment, and she has some positive views on it and some negative ones. But the simple fact is, it's not readily accessible as a court in the ordinary way, and it's to say that that's an answer to all the problems of redress and oversight seems to me quite a bold thing for the government to be saying. So just in the time that I'm allowed, a little bit of history as to why this new legislation came about, and why now. And the basis for it arises from the case that hopefully Laura will talk a bit more about in due course. And it's something called the Third Direction case. And effectively, it was a case about a policy that had been disclosed that was used by or related to MI5, the security service, and set out the guidelines for when they could authorize agents to commit criminality in the course of their deployments. And the judgment which was in the Investigatory Powers Tribunal in the first instance highlighted once again that there has never been any legislation on this issue. We all know it happens, but there's never been any law to explicitly govern how it works, and that was a problem. The other issue was that the IPT held by 3-2 majority, so a very slim majority, that there was a power already from the statute that created the security services that allowed them to authorize criminal conduct. And there was also, prior to that power, the prerogative powers, the royal prerogative, something that everyone will know from, at least from the Miller Brexit case, if nothing else, gave power to the security services to authorize criminality. And so when the Security Services Act came in, it was effectively a continuation of a power that already existed. But that was a narrow decision, and it was a decision that the government no doubt felt might not survive an appeal. And if it didn't survive an appeal, then the stark outcome would have been that there was no power to authorize criminal conduct by the security services. We're very much not talking about the police here. We're not talking about the Gambling Commission. We're talking about agents involved in disrupting terror plots, whatever it might be. But they were faced with the issue that there would be no power. It wouldn't be lawful for the security services to do what I imagine most people think is pretty much all they do, or most of what they do. And so they had to derive this power from the Security Services Act. And all that Act says is what's set out there, is that there is the function of the security service shall be the protection of national security, and in particular its protection against threats from espionage, terrorism, sabotage, from the activities of agents of foreign powers, and from actions intended to overthrow or undermine parliamentary democracy by political, industrial, or violent means. And effectively, from that wording and not much more, the court decided that there was a power in statute for criminal conduct to be authorised, because MI5 had always engaged in that kind of activity. And so when Parliament created that law, they must have intended for that power to continue. And then they got round the prior issue of whether they had a power before the statute existed by saying, well, the prerogative powers provided them with the power to authorise illegality in certain circumstances. And they used the analogy of cases that involved the government allowing effectively committing criminal offences in times of war, which the court said was similar to national security threats. But, and importantly for the CHIS issue and the CHIS 2021 Act and the new powers, the decision that they made rested very heavily on the fact that the powers granted to the security services allowed them to authorise criminality, but specifically did not grant immunity from civil action or from criminal prosecution. And the court used that as a reason why this was lawful and why they could find it was lawful. And as they said, all of this further points strongly to the security service always having had the power by its officers to run agents who participate in criminality, whether possible or actual, in order to fulfill its function to protect the public, provided that there is no immunity from criminal sanction. And again, that their arguments, a similar argument to one that is raised in the criticisms of the new Act, it was that the guidance effectively allowed any type of crime to be committed by these agents. The court said, no, that's not right, because fundamental rights won't be overridden, because there has to be a level of proportionality. But they also said it will be undercover agents are allowed to participate in criminality in the sense they've explained, but without granting immunity for criminal or civil sanction. So it's very clear that they took the issue of immunity very seriously and saw that as a significant part of a safeguard, if you want, or a reason why what was being authorised wasn't fundamentally unlawful or not provided for in statute. So that goes to this issue of the scope of criminal conduct and whether what's allowed by the new Act, for example, basically in principle unlimited criminal conduct, whether that's something that is acceptable, has been accepted by the courts in the past. And in the Third Direction case, they quoted from an earlier authority, the Spycatcher case, where the Master of the Rolls had said that there are very clear limits, as far as he was concerned, to, even when we're talking about defence of the realm, we're talking about the most serious, disrupting the most serious and dangerous activity, that there are limits to what agents can do by law. And one of those, as he sets out there, is that they shouldn't be allowed to commit physical violence, and they can't be allowed, they are not authorised to do so. And the court in the Third Direction case also said that there is indeed a limit to the criminality that may be authorised under the guidance that they were dealing with at that time, having regard to the necessity, public interest and proportionality requirements, and the very real practical limit of arising from the known risk of prosecution, and which the guidance makes clear that there is no immunity, whether for handler or agent. So if we contrast that with the new legislation, there is full immunity for the handler and the agent. The minutes that one of those CCAs is granted, provided that the undercover agent stays within the limits of what's set out in the authorization, he or she will be completely immune. And that's both from criminal prosecution and indeed from a civil action. And so the Act goes much further than the MI5 guidance and goes much further than what was contemplated by the Court of Appeal and the IPT in the third direction case, and was contemplated by them as being and relied on as being a safeguard. And so we're left with the issue of how is it that fundamental rights are going to be enforced in situations where criminal conduct has been authorized? How will victims know that they are victims? They won't have, the only access they will have is to the Investigatory Powers Tribunal, which, as I say, we'll hopefully hear a bit more about. But this Act is substantial in that it does go a lot further than anything that has come before it. The other point is that the use of criminal conduct authorizations under this new legislation goes far beyond the national security imperative that was at the heart of the third direction case. As I said, it was a case that was dealing with MI5, and so much of what is talked about in the judgment is how important disrupting threats to national security is, how ultimately what these agents are doing is saving lives and preventing extremely serious actions. And so that's why it's both inevitable and makes sense that they would be allowed to commit criminal offences in the course of that if necessary. But of course, what we're talking about here, and what I referenced earlier, is not national security necessarily. That's one of the possibilities, but it's not the only one. It could involve preventing disorder, and so that could mean infiltrating protest groups, people who simply believe in a different world or having a system that's run in a different way, and they get infiltrated, and criminal offences may be committed in the course of that infiltration. And so we're not just talking about national security, and this legislation makes that extremely clear. And that's concerning because of, as I've said, the undercover policing inquiry revelations, Kate Wilson's experience, and others that I've talked about. And then the other issue, of course, is the Human Rights Act, and this idea of the Human Rights Act being something that will prevent the most serious offences from taking place, or indeed abuses of this power. But that has real problems as well, because we know, for example, that the deployments that resulted in the terrible things that happened to Kate and many women like her took place mostly, or many of them took place after the year 2000. So after the Human Rights Act came into force, when the people who authorised them should have been complying with the Human Rights Act and should not have authorised conduct that breached it. But of course, those agents did breach the human rights of a number of women and many others, very, very significantly, to the point where it's been conceded by the police that Article 3, the right to not to be subject to torture or inhuman and degrading treatment, that was breached in some of those cases. And so, and as I say, that was all whilst the Human Rights Act was in force, and those agencies, those police forces, were bound by its provisions. And so it's no answer really to say that we don't need to set out any limits to these powers, particularly in law, because these people, they know they're bound by the Human Rights Act. And of course, they would never do anything that's going to breach the Human Rights Act. So I hope that gives a flavour of some of the real difficulties with the new legislation. Now, as I say, there's much detail that could be gone through. There are a huge range of topics that one could speak about for hours, but I hope that gives a sort of more general overview of the problems that exist with it. And Tim will talk a bit more about the code of practice, which is another aspect to this legislation, and some of the challenges that may arise from that. But you will also hopefully get some real perspective on what it means in practice from our other speakers as well. So thank you very much, and I will hand over to the next speaker.
Thanks very much, Jacob. Our next speaker, also a barrister from Garden Court, is Tim Baldwin. He's known for his fierce commitment to representing vulnerable, marginalised and disadvantaged clients. He has appeared in a number of reported cases in the Court of Appeal, the High Court, the Upper Tribunal, and has handled a number of significant inquests. Tim is highly regarded for his public and administrative law practice, which includes civil liberties, human rights, and judicial review of regulatory bodies. Tim is a case reviewer for Advocate and has been nominated in the past for Pro Bono Lawyer of the Year. Many of you will have seen his blog post, which is on the Institute of Advanced Legal Studies website. Tim will take us through the code of practice, whose role he will explain, and he'll highlight some of the problematic sections and consider the route for challenges.
Sorry, I was just unmuting myself. Everything had changed on my screen. One of the things that always struck me about this type of legislation is some of the, not only the extreme acts that the state have been involved in the past in terms of what has come out of the spy cops inquiry, but the level of disruption of political movements by special branch and other policing authorities through the years, to the extent that there is quite a famous case where special branch officers at one point deliberately went out to create what they described as a particularly disruptive anarchist group. Then other people joined that group that had a membership of 7. It then transpired that all 7 of that group were actual members of Special Branch who actually tried to infiltrate the organization that Special Branch had created. So that historically demonstrates really often the lack of control behind the scenes and the lack of proper authorization of activity. What I'm going to talk about tonight is the Chiz Act itself, and looking at what has been published as a draft code of practice. And just to give you a clear overview of where we are with this legislation, there are only 2 sections of this legislation that is actually in force at the moment. It obtained Royal Assent on around the 1st of March of this year, but the only sections that are in force are sections 9 and 10. 10 is just what's called the long title, the long description of the Act. And section 9 just empowers effectively the Secretary of State to make commencement orders, and that is orders bringing the various sections of the Act into force. And really what I've outlined here is what you might call the relevant parts of the Act and what they do, just to give us that framework. So what it does is the Act inserts a section 29B, into the RIPA Act of 2000 that creates the criminal conduct authorization. That is effectively an authorization to break the law, to commit criminal acts. It also inserts a section 29C into RIPA, and that supposedly implements safeguards in instances where the covert source is under the age of 18. And those are what are called juvenile criminal conduct authorizations, the JCCA. It also inserts section 29D into RIPA, And that it implements safeguards in the instance where the covert source is a vulnerable adult, someone with learning disability. So what you have is sort of a general power to commit criminal acts, some form of safeguard if the person you're using as a covert source is a child, and some safeguards in instances where your covert source is someone who is mentally disabled or physically disabled or somehow defined as a vulnerable adult within the Act. So in essence, the Act has considered everybody who could potentially be a covert source, from children to vulnerable adults to any adult. It's also identified the expansion of bodies authorised, that Jacob identified. It's not just limited to security services. It goes down to the Food Standards Agency and so on and so forth. And what it also does is disallow criminal injuries compensations for conduct authorised under a CCA or a JCCA. So you couldn't even you couldn't get compensation if you were injured or harmed out of that criminal act. And what it does is making it a requirement that of the authorisation or cancellation of the CCA to give notice of changes to a judicial commissioner. And what it also does is amend the Investigatory Powers Act to give oversight of the CCA process to the Investigatory Powers Commissioner. So it's a light touch regulation. I think that's the best way of describing it. Whoops. Peculiarly, I was searching around to get some more information on this piece of legislation. And in January 2020, I discovered that the Home Office had produced a draft revised code of practice. You will find a copy of that code of practice within the chat, but the link is there in the slide as well. And when one looks at that, it's described as final. The problem is it can't be final. I'll come to the reason for that in a moment. And it replaces the previous code from August 2018. There was a previous code of guidance. And in paragraph 1.2 of the draft code, it says, this version of the code reflects changes in the authorization of CHIS made by the CHIS Criminal Conduct Act 2020. So it was anticipated in drafting this code of practice that the present legislation would have been passed in 2020 and it wouldn't have gone through all the hurdles that it did in the House of Lords, and then a little bit of a battle within the Commons. So although the date is wrong, it's my opinion that this draft code was designed in anticipation of the content of the 2021 Act. I mean, if anyone has found a different draft code, please let me know. I've searched high and low, but this is what I've found. And at paragraph 1.5 of the Act, it refers to a particular paragraph 1.5 of the code. It refers to particular examples provided, giving illustrations on interpretation, but it's guidance only. And some of the examples it gives is in relation to children who are used as purchasers of alcohol, and when and not would they be considered a CHIS. So particular issues arising from the code. So these codes of practice are issued under section 71 of RIPA and are for use under section 29 of RIPA. So clearly it's a code of practice that is designed to be used under the authorizations under section 29B, the amendments. Now, section 71.3 of RIPA talks about, in 71.3a, the minister shall prepare and publish a draft code of practice and consider representations. So effectively, it appears, as far as I can tell, this draft code of practice is there to be published and invite representations on. But I've not formally seen any formal consultation in respect of the code of practice. And the other issues that arise in respect of section 71, 4 through to 9 is once you've had those representations, the Secretary of State has a duty to consider them, then make the code of practice, lay it before Parliament, and it only becomes implemented once the Secretary of State makes an order. So a piece of secondary legislation authorises its implementation. So what we have at the moment is an act that has been, Act of Parliament that has been given Royal Assent. Most of it isn't in force. There's a code of practice out there that gives an idea of how the act is supposed to work and operate on the ground. That is what you might call the people who authorise these various acts are supposed to adhere to. But that code of practice itself seems not yet complete, because although it's specified as final on the government website, I don't see that there's an order being made implementing it. And I don't see that there's been any sort of formal consultation on it. I may be completely wrong, and other people can correct me on that if I'm wrong, but I've not discovered it to be in force at the moment, and it wouldn't make sense for it to be in force if none of the sections of the Act are in force. And under the definition of a CHIS at paragraph 2.5 of the Code of Practice, in respect of a police officer, what it says, any police officer deployed as a relevant source in England and Wales will be required to comply with and uphold the principles and standards of professional behaviour set out in the College of Policing Code of Ethics. So the draft code indicates what the police are supposed to adhere to when acting as an undercover police agent. They're still not absolved from the Code of Ethics, despite the fact that they can, in theory, be authorised to commit any act and have immunity from prosecution from it. And what happens in the code is that paragraphs 2.4 onwards identify the circumstances for authorisation and use. And 2.17 gives an example of establishing that use. And clearly, what it does is identify when a human source becomes a CHIS, because not all forms of what you might call undercover operation or operation identified within the ambit of the Act would be a CHIS. The classic example is the test purchaser, the 15-year-old who goes into a shop and asks for an alcoholic drink. That within the code does not constitute a CHIS. It's only when there's a relationship, a form of relationship established with the shop owner. For example, if they were meeting that 8 other agents were observing, or they'd attached a listening device to the child. And what the Code of Practice talks about is these concepts of necessity and proportionality in terms of authorising for someone to become a CHIS. So it's not an automatic authorisation. There are very specific things within the draft code that identify how that authorisation takes place. And again, paragraph 3.7 talks about public authorities and these tests of necessity and proportionality, the extent of authorisation of the CHIS. So that there does seem to be within the Code of Practice a notion that a CHIS should have a sort of at least some parameters on, in terms of what they're authorised to do. And there's this notion of collateral intrusion, the notion that you should protect against intruding into areas that are outside the real authorization. And one of the things that I found quite interesting, there's a very small section in there that talks about community impact assessments, and that's at paragraphs 3.25 and 3.26 of the draft code. And it talks about particular sensitivities within the local community. And we all know what that's indicating. That's looking at operation of CHISs within minority communities, for example, Muslim communities where there's a large Muslim population, and also probably in Black and Afro-Caribbean communities, particularly within protests, the protest movements such as Black Lives Matter. So there's that, but when you look at it, it's a very general thing. You've just got to do some sort of impact assessment. It's not clear how that impact assessment is carried out, what it involves, and what the relevant considerations are in it. Also, it talks about the use of CHISs by local authorities. So separate considerations in respect of how local authorities are to use CHISs. And there are particular issues that are identified within annexes, and those concern vulnerable individuals. And there's an Annex A to the Code of Practice that identifies who can authorise what in respect of what particular CHIS source, a child or someone with learning disabilities. And it talks about paragraphs 4.2 to 4.7 and in Annex A, enhanced risk assessments. So within the Code of Practice, it talks of risk assessment. It doesn't really give any indication of how those risk assessments should be carried out, what the relevant considerations are, what the disability, what the compatibility of those risk assessments, for example, with juveniles or individuals of particular sex or particular disabilities are considered, for example, in respect of equality and discrimination matters. There are also considerations of what happens in Scotland, paragraphs 4.9 and 4.8 and 4.9, even though the Act itself is primarily limited to England and Wales, and also international considerations, because the CHIS can be authorised both inside and outside of the UK, and that's at paragraph 4.10. And you've got a whole section on online covert activity, and part 5 of the code talks about authorisation criteria and procedure. So there's a lot there. There's a lot there to look at in terms of, you know, how the authorisation process goes on. And then there's part 6 has the CCA criteria and the procedure there. And there's a whole chapter on safeguards, but it doesn't necessarily preclude the use of particularly sensitive material. And this safeguard section also talks at great length about accessing privileged and confidential information, and also the limits on its dissemination and the use of material as evidence. In particular, it talks about issues around accessing confidential and privileged material, and also legal privilege, and the onward authorizations to provide and disclose matters that are subject to legal privilege. and then safeguards on reporting to Commission. So it talks about safeguards, but it illustrates the extent to which an authority of a CHIS can act. They can access confidential and privileged material, including legally privileged material. So the senior responsible officers and oversight. So what you have essentially is in chapter 10 of the code of guidance. So there's a senior responsible officer and oversight by a commissioner. Those are the two elements of oversight. But what they talk about in chapter 11 is complaints. And this concerns really how compliance with the code of practice is enforced. And there are particular concerns that is highlighted in the code of practice about the use of vulnerable adults and juveniles, and that is set out in Annex A. The difficulty is how would anyone ever know? How would anyone ever find out whether you have been subjected to a CCA or a GCA? How would you ever know that that was going on? How do you ever get to the bottom of it? There are things that are spoken about like in the code of practice, such as errors and serious errors, and the serious errors are those defined within section 231 of the 2016 Act. But the only thing that you have in reality at the end is is a complaint, and it's called a complaint to the Investigatory Powers Tribunal. It's not identified as either a case or litigation. It's described within the code of practice as a complaint.
Tim, I wonder if you could go to your very last slide. We're running a bit over, and
this is my last slide. Great. And I was on my last point. So what you have really is a very, very, as set out, you have a very, very lengthy code of practice. And it shows you how things are supposed to be done and what your remedy is. There's no real oversight by the courts. All there is a right of complaint. And that's it. So I'm going to stop there. It's a bit of a trot through, but I would say take away what's there, the draft code of practice, and have a look at it yourself to see what you can make of it.
Thanks very much. Laura Lazaro Cabrera joins us from Privacy International, where she's a legal officer. She works on surveillance-related litigation, as well as researching and challenging the oppressive use of technology by government and private actors. In particular, Laura is interested in the impact of surveillance on the enjoyment of human rights, even beyond privacy. Prior to joining Privacy International, she was a litigation fellow at the Open Society Justice Initiative, where she supported claimant-side human rights litigation globally. Previously, Laura was a visiting professor at the Inter-American Court of Human Rights. She holds an LLB and LLM in transnational law from King's College London, where she was a Dixon Poon Scholar, and she's a member and scholar of Inner Temple. Laura will take us through Privacy International's concerns with the new law and will highlight possible areas of challenge. Thanks, Laura.
Thank you, Susan. So before I start properly getting into the challenges and human rights concerns, I'd like to tell you all a little bit about the background to the CHIS Act, the litigation that brought it about, and the civil society concerns which emerged since the bill became public knowledge, which sadly, at least to our belief, have not been properly addressed. So the policy whereby MI5 were allowed to commit crimes went virtually unscrutinized until 2012, when Prime Minister David Cameron wrote to the Intelligence Services Commissioner, so the predecessor to the Investigatory Powers Commissioner, asking to oversee aspects of its use, thus requiring the Intelligence Service Commissioner to conduct secret oversight of a secret policy. That in and of itself is bad enough. But what also is and remains shocking to us is that it wasn't officially recognized that MI5 agents were empowered to commit crimes until very recently. And that revelation came about in one of our cases, which challenged the use of bulk personal data sets and bulk communications data, a completely different subject matter altogether than what we're discussing today. The defendants in that case were the Foreign Secretary, the Home Secretary, the MI5, MI6, and GCHQ. In that case, MI5 and MI6 disclosed an extract of a confidential annex to the Intelligence Services Commissioner annual report from 2014. And I'll come to these reports in a bit. That extract referred to 3 directions given by the Prime Minister to the Intelligence Services Commissioner. The first one was public, the second was disclosed in the context of those proceedings, but the third one, crucially, was kept secret. And just by way of general knowledge, the power to issue these directions by the Prime Minister was contained in RIPA under Section 59A, but that has later been repealed by the Investigatory Powers Act. So, as you might have guessed, we initiated legal proceedings to find out what the third direction was, alongside Reprieve, the Pat Finucane Center, and the Committee on Administration of Justice. And it's worth noting that the acknowledgement of the policy happened only after we brought this case, which we refer to as the third direction case, and which Jacob has already alluded to. The third direction, plainly and simply, was effectively the authorization for intelligence agents to commit crimes. And specifically, the direction was for the Intelligence Services Commissioner to keep under review the application of the Security Service guidelines on the use of agents who participated in criminality and authorizations issued in accordance with them. So at this point, we already learned 2 things. First, that agents did participate in criminal conduct. And second, that the practice was so established and ingrained that there were guidelines to coordinate its use. So that third direction came into force in September 2017. But as we found out, and as has been corroborated by research from several civil society organizations, not least the Pat Finucane Center, the MI5 policy on agents participating in criminality existed at least since the early 1990s, and there are indications that earlier versions existed since the 1960s. So what we do know is that this has been going on for a while, but as has already been discussed by the previous panelists, it really is the first time that these powers were properly set into law. So the third direction case, as Jacob already told you, began in 2017 at the Investigatory Powers Tribunal. And by a bare majority, the Investigatory Powers Tribunal found that the policy was lawful. And their reasoning in doing so was that their understanding of the Security Services Act 1989 provided a legal basis for it, specifically Section 1. Of course, our case was then, and still is, that that section only outlines the functions of the security services and provides no powers. Importantly, it is silent as to the authorization of crime. And of course, we believe that it's a very serious implication to read into an act of parliament that agents may be allowed to commit all sorts of crimes without limits. It is particularly concerning that such a power, which is so defiant of human rights generally, could be so easily read into that provision. We took the case to the Court of Appeal, but lost, and we have now made an application for permission to appeal at the Supreme Court. Now, throughout these proceedings for the third direction, it was revealed in the case that we had against MI5 that MI6 and GCHQ were involved in pursuing a similar policy. So the reason why I'm telling you all of this is not to bore you with the details of protracted litigation, but to really emphasize the covert nature of the application of this policy through time, which we believe speaks poorly of the future implementation of the CHIS Act and its application. So turning now to the civil society demands ahead of the act coming into force, or at least a few provisions that are now in force as outlined by Tim, ourselves and several other organizations saw this as an opportunity to set a proper legal basis for conduct that we say had not ever had a legal basis before, and to establish minimum safeguards to ensure the adverse impact on human rights was mitigated. So Privacy International, alongside Reprieve, the Pat Finucane Center, the Committee on the Administration of Justice, and several others requested 3 main things. The first ask was for safeguards to explicitly limit certain types of criminal conduct, such as torture, murder, and sexual assault. But as Jacob has already told you, these safeguards were not included. What we found particularly egregious is that we already have the example of other jurisdictions and other different pieces of legislation that explicitly provide for limits as to the range of crimes that may be committed by agents. So for instance, the Canadian Security Intelligence Services Act has an explicit provision which states that nothing justifies causing death, torture, inhumane and/or degrading treatment, or a violation of a person's sexual integrity. As has already been discussed, safeguards exist in the Act in relation to agents who are juvenile or classed as vulnerable adults, but crucially, it would seem that no safeguards exist in connection to those who may become targets or be at the receiving end of that criminal conduct that eventually ends up being authorized. The fact that no limit is imposed on the types of offenses that may be lawfully committed by agents is worsened by the fact that the test for granting a CCA is relatively low. As we've already discussed, the test necessary and proportionate is broad in that the necessity limit will be satisfied if criminal conduct is necessary to prevent disorder. And this is indeed an incredibly low bar. The second request that we made was for real-time, effective authorization and oversight mechanisms to ensure that authorizations to commit crimes had at least as robust authorization and oversight as search warrants for phone tapping and effective arrangements for post-operational accountability. It goes without saying that the Act does not create a system of warrants or independent judicial approval for the authorization of crimes. All it does is create an obligation for notice to be given to a judicial commissioner where a criminal conduct authorization is granted. And it's worth noting that that section is titled Notification to a Judicial Commissioner. It does not say anything about judicial approval. In fact, prior judicial approval was discussed as an amendment but rejected. And it has already been said that the system in place for warrants is more rigorous than the regime which empowers agents to engage in serious crime, which we believe is hugely contradictory. Interestingly, the Act asks the investigatory powers commissioners to keep the criminal conduct authorizations under review. But in fairness, and at least in our experience, the investigatory powers commissioner's annual report gets released often very late, and sometimes as late as 2 years after the year review. It is very unlikely that details of the criminal activity will be received. Now, it's also interesting here to compare the CHIS Act to legislation in other countries. For example, Canada's legislation requires details of the use of CHIS to be issued in an IL report, as this Act does, but in the Canadian case, the commissioner is required to include not only the number of authorizations issued each year, but also the nature of the acts committed. And this is obviously a stipulation that is lacking from the CHIS Act in the UK. So the safeguards, if we can even call them that, let's call them for the purposes of this conversation, pseudo safeguards that have been included in the Act don't really do much to mitigate the enormous power that is conferred on agents by way of a CCA. So our third, and I would say potentially our most important ask, was to make CCAs a defense to criminal conduct instead of granting blanket immunity. In other words, ensuring that the UK's prosecuting authorities could independently review crimes committed by CHIS and remove the power for MI5 and other public authorities to brand crime lawful for our purposes. For example, again, I will refer to the Canada framework where CCAs operate as a defense to be assessed by the courts. As Jacob already told you, lawful for all purposes means one thing: immunity, both from civil and criminal proceedings, which really prevents proper scrutiny from all these activities to take place. Of course, that suggestion, that request, was not implemented. Now, this has real implications in human rights terms. If agents can freely commit crimes without the sort of safeguards that civil society have called for, put bluntly, we're looking at an enormous potential for abuse. We're potentially looking at multiple human rights challenges that may arise from the application of CHIS, covering a range of convention rights on the basis of Article 2, right to life, Article 3, the right not to be subjected to inhumane treatment and to be protected from torture, Article 5, the right to liberty and security of the person, and potentially even Article 6, which covers the right to a fair trial. Originally, the bill included an explanatory note stressing that public authorities were bound by the Human Rights Act. And of course, we challenged the effectiveness of the statement considering blanket immunity. A reference to the Human Rights Act has been kept as a factor that may be relevant to the authorization assessment, but nothing compels the authorizing authority to actually take this on board. Now, to us, the real problem is the extent to which government believes human rights apply to this section. And really, to our view, to our understanding, they don't believe that human rights are applicable at all. And this is explicit in the Home Office memorandum on the bill, which was made public, where the government stated that they expected for there not to be state responsibility under the convention, where there was the intention behind the conduct that was authorized was to disrupt and prevent that conduct or more serious conduct, rather than acquiesce in or otherwise give official approval for such conduct, and or where the conduct would take place in any event. And again, the government approach was gleaned from submissions that were made before the Investigatory Powers Tribunal in our third direction case. And in that hearing, or in one of those hearings, the government asserted that the state in tasking a CHIS was not the instigator of the activity and therefore could not be treated as somehow responsible for it. And of course, to us, it is contradictory to say that there would be an authorization process in place governed by the government and by the CHIS Act that the government would not in some way be responsible for. So it would appear overall that the government does no more than to pay lip service to human rights. And ultimately, insofar as the new CHIS regime does not limit the type of criminal conduct that may be authorized, it can't be compatible with the European Convention on Human Rights because murder and torture, so Article 2 and Article 3 rights, cannot be curtailed under the convention. These rights are absolute and their restriction cannot be justified under any circumstances. Clearly, the Act does not go as far as outlawing these in a way that is certain. That concludes my presentation.
Thanks so much, Laura. It's a real pleasure to welcome our final speaker, Kate Wilson. Kate is an activist who was deceived into a relationship with the undercover police officer, Mark Kennedy. Kate Wilson was in her 20s and involved in campaigns for social justice when in 2003 she met a fellow activist calling himself Mark Stone. They had an 18-month relationship and remained friends until 2010, when he was unmasked as an undercover officer sent to infiltrate the environmental movement. His real name, it emerged, was Mark Kennedy, and he was married with children. The truth was discovered, in fact, by another activist who'd been in a 6-year relationship with Kennedy. Kate has learned that a number of other people she regarded as friends have also turned out to be undercover police officers. Kate's legal action against the Met and the National Police Chiefs Council cites breaches of her right to freedom from inhuman and degrading treatment, her right to privacy, her right to freedom of expression and association, and sexist discrimination. These battles are far from over, as she will describe. Her experiences give a unique perspective on the new law and the very real reasons for all of us to fear it. Kate.
Hello. Okay, well, so as Susan said, I'm here because last month we completed the final hearings in a human rights claim that I brought in the Investigatory Power Tribunal over real life abuses by undercover officers. That finished in April, and we're still awaiting a ruling, which hopefully, we're expecting sometime in autumn of this year. And I guess the significance of it is this claim by the government that the CHIS bill or CHIS Act is fronted by the Human Rights Act, and that the Human Rights Act offers protection for people like me. And there's major legal issues with that claim, not least the government's threat to repeal the Human Rights Act. But what I want to talk about is what it actually means in practice. So I met a man at an open political meeting at a community centre in 2003. We started a sexual relationship quite soon after that. I fell in love. He integrated himself into all areas of my life, including getting to know my extended family. He spent a lot of time with my parents. He attended my grandmother's 90th birthday party. All of that, I guess, comes under the heading of collateral intrusion that was mentioned earlier. We moved in together and we separated in 2005, but we remained very close friends for 7 years, and in 2010, Mark's girlfriend at that time, who had been with him since 2005, uncovered his true identity, and he was Mark Kennedy. He was a serving Metropolitan Police officer for almost the entire time I knew him, working for the National Public Order Intelligence Unit under the codename Operation Pegasus from 2003 to 2010. And everything about Operation Pegasus was fronted by the Human Rights Act. The kind of abuse that I suffered with Mark isn't unique. We now know, since 2010, a lot of information has been coming out. We now know that sexual relationships with activists and targets of these operations have been a systematic tactic used by undercover officers since at least the 1970s. Since the Human Rights Act was passed in 2000, in the year 2000, I know of at least 12 women who have been deceived into these kinds of relationships. So it's not a historic, and the police kind of try to claim that it's rogue officers, it's rogue units, it's a historic practice, but these are modern policing operations that were authorised under the Regulation of Investigatory Powers Act. And the Regulation of Investigatory Powers Act is literally the law that was written to make secret state operations Human Rights Act compatible. And under REPA, and since the Human Rights Act came into force, we've had women like me being deceived into abusive relationships. Activists are blacklisted. The police have been making illegal blacklists to stop people being able to get employment. And there has been constant systematic spying and manipulation of political groups. And the kind of authorizations that I was seeing in my case were operations that were set up to gather preemptive intelligence on people's intentions to attend political meetings. And all of that was under this very general heading of preventing crime and disorder. That is what the Chiz Bill is using as a basis. It also included extremely invasive spying on grieving families of people who had been victims of police violence, or families like the Lawrence family who were affected by police corruption and the failure to investigate the murder of their son. The whole, there's more and more information has come out since 2010. The whole system is a hotbed of police corruption, institutional racism, institutional sexism, and political prejudice. That the police are effectively protecting their own interests. They're covering up police violence. They're protecting corporate interests. And there's no independent oversight of that. The kind of authorization process that Mark underwent to move into my home was less stringent than the authorization process that they would have had to undergo to tap my telephone. And all of this is now being examined by the undercover policing inquiry, which I think was mentioned earlier. And I'd like to encourage everybody to follow that and to put pressure on the inquiry to make sure that the findings are made public, because at the moment it's an uphill struggle to get the inquiry to cover up the police abuses. And I've just posted some links in the chat, I don't know if everyone can see them, of the groups that are campaigning around that and the ways that you can follow that and get involved. But going back to my case, so in late 2010, the Mark was uncovered as being an undercover officer, and that experience was personally very devastating. And I'm not very good at talking about the personal impact of of that. But towards the end of 2011, I became part of a group with other women who had been deceived into similar relationships, some with Mark and others with other undercover officers, covering a period of about 30 years. And 3 of us, those relationships happened after 2000, when the Human Rights Act came into force, and we filed a Human Rights Act claim in the complaint in the Investigatory Powers Tribunal, but we very, very nearly missed the deadline. And I think it's one of the things that was raised, but that there is this 12-month limitation on being able to bring a claim in the IPT, and the personal distress that surrounded the discovery about what had happened with Mark. In that context, 12 months is a very, very short period of time. And then I actually ended up, I think I had 7 days from starting to talk to the lawyer to the limitations time running out. So it very nearly wasn't possible. And that is compounded by the fact that most people still don't actually know. So many of the people who are core participants in the public inquiry still don't know who their friend was who was spying on them. They know that somebody in their group, somebody in their life was an undercover police officer, but they don't know who, which makes it extremely difficult to bring a claim. And undercover operations by their very nature are secret. And I applied for disclosure, and all of the women that brought the claim with me, we applied for disclosure back in 2011. To date, I'm the only one of those 8 women who has been given any of that disclosure by the police, and I didn't receive a page until February of 2020.
Is that why you're the only one that's got a case before the IPT, do you think?
The reason why I'm the only one who has a case before the IPT, I'm actually not. There are other women who have cases filed in the IPT that are stayed awaiting the outcome of civil claims, I believe. But the main reason why I have a claim in the IPT and the other women who filed claims with me were not able to is to do with the settlements that were reached in the civil claim. So my part of the claim was settled differently to some of the other women, so it was possible for me to continue, whereas their claims were shut down by the settlement process. And actually, when my claim went to the IPT, the police filed an application on limitations, and they tried to say that we were talking about events that had happened in 2003 to 2005, and that the 12-month limitation was well past. And they withdrew that application before it actually got heard, so it's not really clear how that would have gone. But I think that the 12-month limitation in the context of secret undercover operations, where it's a very difficult and slow process, makes it very difficult. Now, my claim now, the police have admitted that the sexual relationship that I had with Mark Kennedy was a violation of my Article 3 right to live free from inhumane and degrading treatment, my Article 8 right to a private and family life, and my Article 10 right to freedom of expression. They've also admitted that at least 5 other undercover operations over a period of 12 years violated my right to private and family life. And we're still waiting on the ruling on Article 14, which is around sexist discrimination, and Articles 10 and 11, which are the political rights of freedom of expression and freedom of association, notwithstanding the sexual relationship. So they've admitted that the sexual relationship was a violation of those rights, but not that the police intrusion into the political communities that I was part of was a violation of those rights. So that's what we're waiting for. But that process took more than 10 years. And in addition to the limitations application that they filed, the police filed application after application to disrupt. That they filed 3 different defences. They admitted stuff, they withdrew admissions, and they basically tried to block disclosure every single step of the way. And one of the other issues that I would flag about the Investigatory Powers Tribunal is that it's what's called a costs-free tribunal. And in principle, that's a good thing. It's meant to make it possible for people to bring a claim against the state without risking bankruptcy at the end by being forced to pay costs if they lose. But what it actually means in practice is that the state is able to use essentially unlimited public money to bring those kinds of repeat applications. And what that meant in my case was that I was almost priced out of court. I ended up having to represent myself as a litigant in person for 13 months. My case was an extremely complex legal case. It involved, we prepared for 12 separate in-person hearings. All happened. Some of them were stopped by COVID, some of them by the police withdrawing applications. There was a closed part of the process. It involved around 7,000 pages of disclosure and several years of battling over even getting to see that disclosure. And I was extremely lucky to have the opportunity to fundraise through some of the Spike Ops campaigning, and also to be represented pro bono by various different points in the 10 years by Berg Pierce and by Freshfields Brookhouse Derringer and Charlotte Kilroy QC and barristers from Blackstone Chambers. And you know, that is not resources that anyone is going to have access to. And even in that context, bringing the claim basically took over my life for a decade. And so we did ultimately achieve a number of rulings, and we're still waiting to hear about others. And we did ultimately get some disclosure, but I think, I mean, so in my case alone, we've reached the point where it's clear that there were serious human rights abuses by at least 6 different undercover officers over a period of more than a decade. That was all as part of operations that were fronted by the Human Rights Act, that were authorised under REPA, that were reviewed and signed off several times a year by police commanders. And those were systematic abuses that didn't just apply to me. And of the many, many people who have been trying to bring these claims, mine is the only one that has made it that far. So yes, I think that, first of all, I think it's clear that the system doesn't work. The Human Rights Act doesn't protect people if the people who are responsible for making sure the police don't breach it are the police themselves. So without some kind of independent oversight, it doesn't work. And then the system for actually making a complaint is so difficult and so resource intensive and so complex that I don't think it really counts as a recourse for most people in the face of what are secret operations, where there's almost no opportunity for people to even find out what has happened, let alone be able to bring a case. And I guess that's all I'm going to say for now, but if anyone has any questions, then.
Just have a quick question for you, Kate. You mentioned that some of the hearings were closed hearings, and I just wondered how that affected what you were trying to achieve, what your reaction was to some of those hearings being closed.
It's a very strange process. So the there's a figure in the Investigatory Powers Tribunal called Counsel to the Tribunal, who's like a third legal team in the process, whose role is to advise the tribunal, but also in the closed processes to not to represent me, but to make sure that my interests are represented. So it's not a special advocate. It's very, took me a long time to understand the role. The closed process is very strange, because you can ask questions, but you don't get to see the answers. You can make submissions, but you don't see what the other side says. And I was, I think, actually very lucky in the sense that when the police reviewed my, when the IPT first looked at my case, the police applied for the whole thing to be heard in secret. And I don't think that's very unusual, actually, in the IPT. Like, usually cases are heard completely in secret. I would have no access to any of the disclosure. I would have no access to the hearings. I would be able to make my argument, and then there would be a ruling. And I don't think I would even necessarily get a reasoned ruling. I would just be told whether they found in my favour or against. And the Investigatory Powers Tribunal looked at this case and said that the secret, I'm paraphrasing quite a lot, but they said that the secret proceedings that they have and the closed proceedings that they have don't exist to protect people from embarrassment and wrongdoing. You know, they are actually restricted by national security considerations, and not they're not a blanket thing, but they are very, very often used, and I think that would be another barrier to people really being able to find recourse in the Investigatory Powers Tribunal. I don't know what the Privacy International experience was of the closed proceedings, but
Laura, did you want to address that?
I have to agree with everything that Kate has said. There is some good and there is some bad, and unfortunately, it's hard to know exactly what happened. So you can only come away from the Investigatory Powers Tribunal with limited information. In our case, one good positive that we had once is that we had confirmation from the IPT that we had been spied on alongside a myriad, several other organizations. At least there was that certainty that we were able to derive from that process. But in general, yes, there's only so much that we can learn from the IPT.
Thank you. There are a number of questions, and I think all of the panelists have taken a look at them. There are in the Q&A. Also, John Fuller, I just wanted to read out the comment he made. I think this was after Jacob's talk. I think it's important to note that Extinction Rebellion was created to stop the killing of billions of people and the sixth mass extinction of wildlife. We came together in exile precisely because the state had abandoned a core national security function of keeping the people safe, which is to say, these things are not one or the other. Often it's the state failure that people are highlighting. There are a number of questions. Any of the panelists want to jump in the interest of time to answer any of the questions that have been put in the Q&A?
I got kicked out by accident, and I can't actually, the Q&A is empty for me for some reason.
Okay.
It's because I got kicked out and came back in, so I can't see the questions, I'm afraid.
Oh, sorry.
It's okay.
There are a couple of comments, Kate, about your experience. One comment is, I was told by a retired Met officer that they infiltrated Notting Hill race rioters using the same tactics. So it goes way back. Women are seen as collateral damage and no responsibility is taken for the harm done. Politically thinking seems to be any means justified the end, and that's regardless of political party in charge. It's very, very sad. So sorry for you, Kate, and all you've been through. Thank you for speaking today. I'm sure we all echo that. It's very difficult to be the person who ends up the face of which is what you have become, because the press coverage has really focused on the way that you've brought these issues forward by pushing your complaint through the IPT and through your participation in the undercover inquiry as well. Huge thanks for that.
Yeah, I mean, it's complicated because of how extremely personal a lot of this stuff is. A lot of the people who are campaigning around it have anonymity from the courts. So it's quite difficult to get people's voices out there, and there are a lot of good voices. I believe that 5 of the women that I brought the case with are about to publish a book, so I will shamelessly plug that. Not my book.
Please do. Any of the panelists want to address any of the questions that have come up in the Q&A?
Maybe Jacob can also come in on this. There seem to be several questions that really talk about indirectly the issue of immunity and what can be authorised. For example, there's a question from Jim, and it says, could undercover cops be charged with rape or domestic abuse? They have sex with victims of the undercover operations. I think partly the answer is that although the Act gives sort of a broad immunity, if the code of practice has any teeth, there's paragraph 615 of the code of practice, and it talks about an application of the authorization of participation in criminal conduct by a CHIS. It talks about should be in writing and record sort of a series of bullet points. For example, it says the use in conduct authorization, which it relates. It goes through a whole series of bullet points. And then it says at the 4th bullet point, the nature of what the criminal conduct will be. So it seems that at least in the nature of what is supposed to be authorized, the criminal conduct will have to be defined. And then also the reasons why the criminal conduct is considered proportionate to what it seeks to achieve. So the simple argument would be is that the nature of the authorization itself defines the scope of the activity that is lawful in terms of the criminal conduct. If the criminal conduct that actually occurred outside of the authorization, then the person would not have immunity for that. Still the difficulty is, as Kate said, finding out about it. Finding out that the individual is a CHIS. So I mean, you have the scope of the authorization. So if there was criminal conduct that wasn't caught within the authorization, the person would be charged with it. And if that offence was one of violence, physical violence, rape, domestic abuse, then even if that was authorized by the CHIS authorization of CCA, it would be really hard to understand how it could be justified in terms of the reasons and considered proportionate in respect of what seeks to achieve, particularly when fundamental rights have no proportionality consideration. But again, it would be accessing that information and identifying, trying to actually identify that the individual was an undercover source, especially when there's no there seems a very light touch review and oversight process.
Can I just add to that, because I think that there is another issue there, which is that 2 women actually did seek to bring rape charges against undercover police officers based on the kinds of relationship that I had, and the CPS wouldn't take them to court. And I think that there's a major issue around the undercover policing, which is the role of the Crown Prosecution Service in covering up the undercover operations. And there's been dozens, certainly dozens, possibly over 100 miscarriage of justice cases brought since these undercover officers were discovered, due to the role that the CPS played in covering up their involvement in cases, and people basically being wrongfully convicted with information being withheld from the defence. So immunity, there is the kind of statutory immunity that you get from the Chiz Bill, but there's also the in practice immunity that you get from the way that the system is structured.
I think all I was trying to indicate was that, although it's not within the legislation per se, the code of practice suggests that there is a limit on the immunity that can be given, under, at least under the legislation.
Yes, that's right. I mean, the legislation, or at least certainly the government in explaining it, seemed to suggest that if the authorisation could be shown to breach the Human Rights Act, a particular ECHR right, then it would be invalid and therefore wouldn't have any effect. But I think, as Kate set out, the practical reality of achieving that kind of finding is very, very difficult. There's also going to be a lot of argument, if you look at it from the Chiz's point of view, that actually what they've done is still within keeping, certainly, with the spirit of an authorisation, and they may be able to argue successfully that actually, even if they did go a bit too far, that it wasn't wholly outside of what they were being authorised to do. Just on the point about the rape issue as well, is that there is a difficulty in whether that is strictly legal terms, that kind of activity of deceiving women into relationships, whether that actually meets the legal test for rape. I don't say that remotely from that being something that I think is right, but it's just that the CPS would have looked at it from that basis, and whether they decided not to prosecute on that basis. But I do know also that in cases like Kate's, that the CPS have refused to prosecute an officer for the offence of misfeasance in public office. And unless that officer is being authorised to do what they're doing, which the police have said in Kate's case and others, that isn't really what was happening, then it seems extraordinary that there was no prosecution of those officers for the offence of misfeasance in public office. And so there is genuinely some real issues with the way the CPS have approached these issues as well, and that's even after you've gone through this enormous hurdle of trying to find out whether you've actually been a victim in the first place.
Just want to give the last comment to Laura, because it's been a while since we've heard from you, and then we'll wrap it up for the evening.
I've seen one question in relation to the Intelligence Powers Bill and judicial sign-off after a week of surveillance. I have to admit, I'm not sure what the Intelligence Powers Bill is, but from my understanding of the Investigatory Powers Act, if you request, or if an authorized person requests a warrant for interception, and if they do so without having sought judicial approval, first and foremost, they have less than a week to actually get judicial approval ex post. So there should never be a circumstance where a week goes by and a person has been the subject of some sort of interception warrant and there's been no sort of oversight. That situation should never go about, as far as I'm aware.
Thank you very much. And thank you to all of our panelists. Thank you for the participants as well for staying over. We ran a bit over, but I wish we could have gotten to everyone's questions. Thank you. And please follow up when you get the materials from us with people's PowerPoint presentations, because there's a lot of work to do ahead. Have a good evening.